Hello friends! So, there are a lot of serious publications in social media and questions from people like how to avoid claims from clients with existing outbreak of coronavirus, how to be paid being quarantined when company asks you as an employee to stay home, and others. I'm Stan, experienced professional in contracts and procurement, and I can give you some advice how protect yourself and your company in such situations, or minimize your risks, or share such risks with other companies. If after this video you still will have some questions, please write your comments. I will answer to each of you and we will try to solve your issues together. Well, based on practice and experience, only well-written and clear article regarding force majeure provisions can help you in this subject. Normally, provisions regarding force majeure clause should be included in each contract and agreement. And it does not matter is it contract between two entities or contract between employee and company. Okay, for education purposes, all examples should be simple and the description should be simple as well. Okay, in general, we can say that force majeure clause is a provision in a contract that excuses a party from not performing its contractual obligations that becomes impossible or impracticable due to an event or effect that the parties could not have anticipated or controlled. These events include natural disasters, sometimes called as acts of God, as well as uncomfortable events such as war or terrorist attack. Force majeure clauses are meant to excuse a party provided that failure to perform could not be avoided by the exercise of due diligence and care. In order to start our conversation regarding force majeure, let's take for instance the following simple contract structure. I divided it into 9 groups. First is purpose or subject matter, where should be clearly stated what about this contract. Definitions, where all used definitions should be described. The following is contract price, where should be specified all rates and prices of your work, services or good. The next is scope of work or goods or services to be provided. It depends from your business area. The next is if you are employee or freelancer, or your company obligations and your client obligations as well. So normally a lot of obligations should be described, but you should perform your obligations under this contract or agreement, and other parties should accept all your works or goods which will be provided and duly paid. The following is payment terms, how you will be paid under the contract. A payment mechanism also should be described here. And the last is warranties, and I called it as other provisions, which normally include applicable law, assignment, termination clause, conflict of interest, maybe intellectual property. It also depends from business area you are operating in. And let's start from definition. And there are 2 ways to define force majeure. First, don't forget to ensure, or if you are drafting the contract, personally define force majeure, because it's a key thing. Correct and complete definition and correct references will make force majeure provisions work. And normally force majeure could be included right in definitions. It is the second group we reviewed above, or right as a separate article in the group which I called as other provisions. Somewhere between assignment and termination clause, because a lot of contractors, freelancers and employees are afraid of that due to force majeure conditions, contract or agreement could be terminated. And speaking about definition, and to be honest, there are too many definitions which you can find in the internet. I would propose the following simple wording for you, that force majeure is an unforeseeable circumstance that prevents someone from fulfilling the contract, which renders the invoking party unable to comply totally or partially with its or his obligations under subcontract. So you see that force majeure should work as for you as for your client. It's also important to specify what does force majeure include and what doesn't. So based on available resources and my experience, I described all potential cases where force majeure could take place. And please pay attention that the first one is epidemics and disease, what we have for the moment. And it's also important to describe what shouldn't be included in force majeure, because it's better to protect yourself and avoid cases when other party will not carry out its obligations under the contract with reference to force majeure circumstances. What I mean, it's like failures to obtain approvals, license permissions, some fluctuations in exchange rates of currency, failure to make a payment in accordance with the contract. So be attentive. The next step after force majeure was carefully defined. It's important to make it work for your benefits. And it usually should be done in terms of payment conditions and terminations clauses. We will review two cases, for companies and for employees or freelancers, and we will start about payments. In terms of commercial relationships between companies and legal entities, the fair thing will be when each party will bear all costs and financial consequences of such force majeure separately, and all works and services or goods supplied by you or your company prior to force majeure cases, prior to force majeure occurrence, and duly accepted by client, should be paid. This is about case between companies. Another case is when it's relationships between company and employee. So here I would propose the following wording: work performed by you or your company prior to force majeure occurrence and during force majeure and duly accepted by your client shall be paid in accordance with the contract. So you see that your client or other party has no rights not to pay for you or for your work or for your goods. Okay, and here you can ask, what about if my client, other party, is not going to pay me and decides to terminate our contract? For these purposes, I would like to suggest the following wording to add in termination clause or whatever it will be good to include in your contract in order to avoid such termination cases. And the idea of this wording could be divided into three main bullet points. The first is affected party shall notify the other party within some period of time, normally it should be 5 or 7 days, of the date which the force majeure ceased. The next is if the situation of force majeure extends over a period of time more, for example, 20 or 30 days after its notifications, parties shall meet in order to jointly decide on the required measures to be taken. For example, if you're an employee, you can decide with your company that you will stay at home, will work from home, and you will be duly paid for your job. And only then you can specify conditions for contract termination due to force majeure circumstances. Friends, I really hope that this knowledge can be useful for you in your existing cases or will be useful for your future. By the way, I put all wording we reviewed here in the MS Word file for you. Link you can find below. Please enjoy. Don't forget to put your likes, please, subscribe and share your comments. Any questions, please comment. I will answer on your question. Feel free to contact me. Cheers and stay safe.